What's going on, guys? Welcome to another episode of Smash JT. I took some time today to sit down with Ron Coleman to discuss my ongoing lawsuit with Alyssa Mercante and what we feel like is a frivolous lawsuit bringing up a bunch of lies and just ambiguous things to say I have my fifis hurt and this person's a bad guy, which as far as I know is not illegal in the great states of America. But that being the case, it doesn't stop someone from actually throwing a lawsuit at you. So in the current predicament that we're in, the amount of money that has been donated via the GiveSendGo was substantial. Don't get me wrong, it was over $61,000 up to this point. And in chatting with Ron Coleman behind the scenes and even a little bit into this interview, he let me know that it's going to take more than that, potentially a lot more than that. And this is kind of along the lines of what a lot of people were saying, that this is not going to cost 25,000 bucks like I was originally hoping with the original retainer. That was child's play when it comes to lawsuits, and that was really just getting the tires rolling on this. And there's been a ton of people, like tremendous amount of people, who have said, I'm here for you. If you need more, let me know. This right here is me saying, yes, I need more, and I'm letting you know. So if you do want to continue to support fighting back against Alyssa, please consider going to the GiveSendGo. I will link it in the description as well, and I'll pin the comment as well. And I have set the new goal on the GiveSendGo from $25,000 to $200,000. But I want to be clear about any of the finances and money going into this lawsuit, like I was from day one with it. This is not a financial gain for me. This is not something that I'm looking to try to monetize and be able to make money off of. I just want all of this to stop. I think it's ridiculous what's happening and how it's already gotten completely financially off the rails, out of control. And I want it to end. But you can't just do that with a lawsuit. You need to be able to fight back financially. And any money that I make from this, I plan 100% intentionally to be putting towards that lawsuit like I already have, and will continue to do so until otherwise needed and hopefully goes away. But with that being said, I know I'm kind of going off the rails with this here. It's a very stressful time to deal with finances when it comes to a lawsuit. And you guys have been incredible. I don't know how I'd be able to do this. I wouldn't be able to do this without you. And I genuinely mean that. And you guys who know me would know that. So thank you for everything you've already done. And without further ado, now time for Ron Coleman to answer some of the pressing questions and discuss what's going on right now with our lawsuit and what the future might hold for it. I am joined by my lawyer, Ron Coleman, in regards to the Alyssa Mercante lawsuit. And Ron, how you doing?
I'm all right, thanks. A little bit muggy and warm here in Newark, but that's what New Jersey in July is about. That's the deal.
I hear you guys are getting a little bit of flooding there.
Oh my gosh, it was insane. Although I didn't, like, right here, Newark is looking out the window at the west side of Manhattan. It might be that here along the coast, even as far west as my home in lovely Clifton, New Jersey, the pearl of Passaic County. I don't think we got the kind of water that I was seeing video of. Insane
Oh yeah,
stuff.
I've seen some crazy stuff too. Yeah.
Thank God.
Yeah, no, that's good to hear. Good to hear. Well, without further ado, let's get to the meat of this, because I know a lot of people have been asking me specific questions regarding what's happening with the lawsuit, next steps with the lawsuit, the financial situation. I don't know if you can even get into that, but whatever is, we'll throw it on the table and see what you say. But
Yeah.
first things first, just to catch everyone up to speed, the latest transactions in the lawsuit is we have received the plaintiff's memorandum of law in opposition to defendant's motion to dismiss.
Yeah.
Any thoughts on that?
Well, it is exactly what was supposed to happen. We agreed to a date. They needed more time. They needed more pages. Here's how it works. We made a motion to dismiss, as you are well aware, on 2 grounds. One, you have no jurisdiction over the person of Jeff Tarzia because he lives in California. We're in New York, and he's really got nothing to do with New York based on the complaint. Okay, a motion to dismiss based on either the claims of the complaint or on jurisdiction is going to be presumptively based on what's in the complaint. In addition to the jurisdictional ground, we also said, and even if you do have a jurisdiction over him, or a judge, if you're inclined to just dismiss it on the merits, we can live with that. Here's why, notwithstanding how much fuss and how much stuff they threw at the wall, this does not state a claim for which relief can be granted under the law. In other words, it ain't defamation or any of the other claims that look like defamation, but that they've called other names. And New York law is clear that when you have claims that what lawyers say is that sound in defamation, which I think the closest thing to that in a normal person speak would be they sound like defamation. They quack like a duck. So if you have a tortious interference claim or all kinds of different ways of slicing what still is basically defamation, you get the same level of defamation protections, and they're not considered to be separate claims unless you really enunciate a difference. Okay, that was our motion. One of the other judges, this case should be booted. They have one thing that we can say, I think, confidently is that this was and is not meant, this lawsuit, as a just impose a little bloody nose. And we know that it's very hard to win a defamation case, especially in New York, but we want to just push back a little bit. They're absolutely serious about this. They have invested a tremendous amount of lawyer time and resources into this process. One more point. Usually in most courts, including by far the majority of federal courts, when you file a motion with the court, party 1 files the motion to dismiss, party 2 files the opposition to the motion to dismiss. There can be a party 3, but in this case there isn't. Party 1 then files what's called a reply. Reply is, here's why their opposition. What did they say in My Cousin Vinny? That's why what he said is a bunch of bullshit. Okay, that's basically what you're saying. Because you're the one who has the burden of getting the court to do something here, you get last licks. We are now in the last licks stage. However, in the Eastern District of New York, which is essentially Brooklyn and Long Island and a couple of other obscure places, there's a special procedure that the judges have, which is you guys share the papers with each other. And when you're all done with your papers, we don't want to have to watch the docket piece by piece. That's just too hard for us. I don't know. But you guys file, when everyone's done with briefs and arguments, submissions, do that all at once on a date that you guys work out. So that nothing has been filed yet other than our scheduling order for the motion. And what we do is file a cover letter to the court saying, okay, we've met our deadline to serve the other party with the papers. So now we've been served with their opposition. This is the second time we've made this motion, as you recall.
That's why I was going to follow up on that. I'm like, haven't we already done that?
So we did do it, and we did it so well that they did something that they are allowed to do once, which is to read our motion and say, oh, okay, yeah, all right. We want to file a new complaint which will address your issues, because we still believe we have a claim, but you have identified certain pleadings issues, technical deficiencies that we're going to improve, that we're going to fix up. And the idea is, instead of the court granting our motion to dismiss without prejudice and then
doing another case type thing.
Yeah, there are all kinds of ways to do it, but this is how we do it now in the federal court, is they get to look at it and say, okay, we want a do-over. So they got their do-over. They filed an amended complaint, and then shortly before our motion was due, they filed a second amended complaint, because apparently they found even more super damaging stuff. I never really figured out what that was, but I'm sure there's very good reasons for it. And now we're on track 2. There's only one. This is the only track under almost every circumstance that there will be. We filed our motion to dismiss, not filed it. I say filed it because, again, like that's how it is in most courts, but we served our motion to dismiss and they have now served their opposition. And we now have the opportunity to reply, the last licks. Therefore, we have.
Before we even get to that point, let me just ask one quick question. Does it look bad for them to the judge, or does the judge not even see any of this because it hasn't officially been filed to the court with all this stuff yet?
Oh no, the judge is aware of it because
Okay.
it doesn't look bad. It's actually a fairly, well, let's put it
Common.
this way. It is common on the one hand, but on the other hand, when you have filed a complaint in a non-emergency kind of footing like they did, in other words, they've been threatening you for many, many months,
Mhm.
and the legal issues that we identified, the technical and legal issues that we identified in the first complaint are the kind of things that anyone doing his research would have anticipated when preparing the first complaint. No one's perfect, of course. Lots, there's no shame in filing an amended complaint, but it's not as strong a position as not having to file an amended complaint. But in terms of weight on the scale, nah, it doesn't really make a difference.
Gotcha. But I didn't mean to interrupt you. You were saying, so the next steps after
The next, so we have had, you recall they actually said to us at one point, why don't we skip the motion to dismiss, or why don't we skip the motion to dismiss, and you just tell us what our issues are, and we can amend. We can take our free second bite now. And you and I discussed that,
Mhm.
and your decision was, I want to make the motion. I want to put them to it, which
Mhm.
is absolutely, you're right. So that's why it feels like we've done a lot of this, because we have done the motion twice. Fact is, we didn't have to make a lot of, notwithstanding the fact that they filed 2 amended complaints after their original complaint. Our motion isn't all that different. I don't think that they did too much to improve their pleading.
Mhm.
It is a lot of work went into their pleading.
Mhm.
I'm not sure that it was useful work. I'm hoping the judge agrees with us. On the one hand, they've done a lot of work and they have definitely besmirched you.
Mhm.
And remember, folks, when we're talking about a motion to dismiss at this stage of the case, basically whatever is in the complaint has to be taken as true. One kind of unusual aspect of a defamation case, though, is that we are allowed to demonstrate the context that they don't supply in order to understand whether, as a matter of law, a comment by you was defamatory. We now have the reply. The reply is supposed to be short and sweet. It will be. When that is finalized, we will serve it and we will file it. They will serve their stuff and it will be filed. We will then go into hibernation. The judge will take the whole thing up, put it in a basket, throw it down the stairs. No, that's not how the judge is going to do it. This is a thoughtful judge, a responsible federal judge. This is not the kind of judge who tries to take over ICE or the Defense Department or any of that stuff. It's just a regular New York federal judge, and people want to know, how long will it take for the judge to decide? It will almost certainly be more than a month. I have a defamation case in which I represent the plaintiff, Gavin McInnes, in Alabama. We are now going on 6 years that we've been waiting for the judge, but that's because the judge
Holy.
there is sitting on it, and we're gonna have to go into a certain kind of motion practice to deal with that. But
Jeez.
I don't expect it will be 6 years. I don't even think it'll be 6 months. The turnaround in the New York federal courts on defamation cases seems actually pretty good to me. I think that it will be probably a couple of months. It is very difficult to sustain a defamation claim in New York, especially since New York really put a lot of teeth into its anti-SLAPP law, which makes it unlawful to use a lawsuit to try to just shut somebody up. So I like our chances.
I like our chances too, but that being said, there's never obviously a guarantee of anything. And
Thank you for recognizing that.
Yes. I have to reinforce that with myself to never get overconfident, no matter how confident I feel about something, because you never know until it actually happens. With that being said, I do have a few questions to follow up on this. One, the jurisdiction is a real sticking point to me, and I've had a lot of people, including myself, question, like, at this point, why is the judge continuing to even hear it if jurisdiction is the end all be all? Like, yeah, it doesn't matter what you guys have to say. I can't hear this case because jurisdiction. Why is it even at this point right now?
Well, before answering the question directly, let me just point out that dismissal on the basis of jurisdiction is likely to be without prejudice, meaning the court can either dismiss it and say, now go file it where it belongs, which would probably be California,
Mhm.
or I'm going to just transfer it to where Jeff lives and
Start all over again.
start all over again.
Jeez.
So it isn't necessarily such a great outcome, and we've got to litigate it somewhere.
Mhm.
But the straightforward answer to your question is the judge doesn't move until the motion is fully briefed. A judge doesn't just look at the papers and say, I don't see jurisdiction here. That's not how it works in the American justice system. It is an adversary system. So I have to be the one to say to the judge, hey, judge, why are we discussing this in Brooklyn or in Long Island? This doesn't seem to have anything to do with either of those places. Not even though the plaintiff lives in Brooklyn under the applicable law affecting where cases are supposed to be filed, this doesn't seem to be the right one. We could have probably gotten this done a lot faster if we had only made a motion to dismiss on the ground of jurisdiction. That's a much simpler motion. But in a situation like this, you almost always also make the substantive motion to dismiss, which we have done. And that's why it's taken so long to get to this point.
Gotcha. That makes sense too. And a follow up to that as well would be, I guess, a couple follow ups. One, in their latest filing of this, what's it called? Opposition to defendant's motion to dismiss. I'm trying to get all these verbiage correct here. What of I mean, I haven't even finished reading through all this because it is 44 pages. There are a tremendous amount of lies, both wrong factually and lies by omission, lies missing context, lies that do not portray a situation the way reality actually was. How does that matter when it comes to a judge reviewing something? Does the judge care, or are they just throwing everything at the wall to see what sticks just to get this heard? And then they'll try to fight that battle in the court of, well, we didn't mean that. We made a mistake with this. We made a mistake, but at least we're being heard here, which is what it feels like they're doing.
Well, that is what they are doing. The judge, the judge's job on a motion to dismiss is not to weigh evidence. But on the other hand, he's also not supposed to consider evidence. He's supposed to consider what's in the complaint. So if they've added all kinds of new allegations that were not in the complaint,
Mhm.
that go beyond context or go beyond things that were referred to in the complaint, in other words, if you link to a video or if you give a URL of a video
Mhm.
in a complaint, you can't you it's really awkward and difficult to file an actual video in a lawsuit, almost impossible. Uh, so you say, here's the URL, the court can go look it up. Everything in that video is part of the complaint, just like a contract that you refer to. Everything in the contract is part of the complaint. That's beyond the four corners, literally, of the complaint, but it's considered to be something that may be considered a motion to dismiss. But if they're adding all kinds of affidavits or all kinds of screenshots that go beyond that, the judge, by right, shouldn't be considering it at all. Here, it is a little bit different because we also made a motion for sanctions under the New York SLAPP statute, which require the court to make an analysis of whether they had any basis for bringing this claim, both factually and legally. We'll address how their submissions do or don't fall into any exception that might be available that way in our reply.
Okay. And I guess finally, speaking of the SLAPP situation, is there additional follow-up required for a SLAPP request or anti-SLAPP, whatever it's called, beyond what we're about to be doing right now? Like, do we formally submit a reply to this as the last licks, as you said,
Yep.
and then the judge will hear something and then say something, and then we need to file another like official motion for SLAPP and stuff like that? Is that the next step after this, if the judge is open to that, or what?
There, when the law was first passed in New York a few years ago, the way it read made it seem as if it was necessary to bring a separate action, or in this case, it would be a counterclaim under the SLAPP
Mhm.
statute. But the New York courts, both state and federal, have consistently held, not universally, but rather consistently held, that that isn't necessary. That there are two things going your way in terms of what the courts have said. One, you don't have to bring a separate action or even make a separate motion. It's enough to say, as part of your motion to dismiss, not only should this be dismissed, this runs afoul of SLAPP, and if it does run afoul of SLAPP, attorney's fees are mandatory.
Okay.
And B, there's been a very strong string, not a wrong string, of New York cases, including again in federal courts, that have said, if you get a motion to dismiss, if you succeed on a motion to dismiss a defamation or a SLAPP case, you have satisfied almost by definition. I don't know if they say by definition. They might even say by definition. That strikes me as perhaps a bit of a stretch, but you have done what you need to do to demonstrate that it was a SLAPP case. So because this, as far as I know, the Second Circuit has not necessarily the federal appeals court that determines the proper procedure in the federal courts in New York. I'm not sure that they have weighed in on that, but and for that reason, the judge may have druthers. He might want to see more on that topic. But all things being equal, we have a very strong argument for saying we've done our job, judge, and you can now award those anti-SLAPP actions.
And that being the case, I guess the final, because that just reminded me, the financial aspect to all of this, because the whole purpose of the SLAPP statute is to prevent people like what Alyssa is doing to financially burden someone that doesn't deserve to be financially burdened, would be my take on it. And that being said, I don't know if you want to get into the exact numbers of how much you have cost me thus far. And thanks to the community support, we've been able to cover those bills. But in our private conversations, it may end up costing more than what we've paid so far, and most likely will.
Well, it will, because we have we have to do the reply submission. So
It will end up costing more. And that being the case,
these are whenever, just folks should understand, whenever Ron Coleman, I learned this from Harmeet Dillon, whenever you do a crowd-funded case, it's public interest. You should be doing it pro bono. Now, pro bono doesn't always mean free. I've done plenty of free work in my life. This ain't one of them, because everybody in the world wants Ron Coleman and people like him to do this kind of work. So we would be overrun, but you're getting a substantial discount over my regular rate, like on the order of a third.
Yes, and I have noticed that as well in the billing, and I appreciate that. I genuinely do. I guess my greater point with all of this is, though, that it's almost like the SLAPP statute is in effect to stop people doing what she's doing. But if I didn't have the community support, how would I have paid this? How would I, as just a normal run of the mill dude, just living his life, This is a financial burden that without the community support would have destroyed and wrecked my life.
This right. I mean, this defense at full price by a competent lawyer, an experienced lawyer, which doesn't necessarily mean as experienced as I am, but isn't less than $50,000 and easily could hit $100,000 just at this stage. Most people don't have a legal fund on hand for that kind of stuff in their lives. That by far most Americans don't have that kind of money for anything, just sitting around. You, of course, are an incredibly successful YouTube streamer who has profited greatly, we're told, by mentioning the extremely magnetic and
I mean, they really do build me up over there, don't they?
well, not just you, but your the cadre of New York friends
Oh
that
yeah,
you
yeah. It's
who
actually
follow your every direction.
apparently.
And I've learned, I can't really disclose the specifics of it, but I've learned the code words that you use so that they know what to do and when to brush their teeth, and whose couch you sleep
Oh
on
yeah, yeah.
4 nights a week when you're in New York. Uh, but the answer is it's almost impossible. It's almost impossible, and that's why the anti-SLAPP statute is here now. Here's the weird thing:
Mhm.
we have no reason to believe that the plaintiff in this case could pay your attorney's fees. That doesn't mean that she wouldn't be subject to enforcement proceedings to find out if she could pay them, and all the things that happen when a judgment is entered against you. But that raises the question: how can she afford to litigate this case? Because presumably approximately the same amount of work is necessary on both sides.
And she's got 3 lawyers, not 1.
Right. But I'm equivalent to 3 lawyers.
Right,
So
right. True. I just want to be clear about that for everyone who doesn't know.
the
cost
answer,
is exorbitant,
so
I think.
I have every reason to believe that this is a form of this is pro bono work by them, that they're doing it as a form of what they consider to be the public interest,
Mhm.
the forwarding of their agenda. I don't really think she thinks she's going to get damages from you. I think it's impossible to prove damages in this case, but in any event, your point is well taken. It's a very this is the problem with American law, but it would also be the case anywhere where you have access to the courts and judgment-proof parties. I don't want to say that it's abusive. I don't think this, it's really not all that much worse than a lot of very common. And by the way, I know they listen when I appear on your show, because they
Mhm.
then go on to quote our conversations in their papers as a
You'd
fact.
be impressed how much they listen when you're not on my show too.
But they I know that, I know also. I like how they believe that it's some incredible coup to quote me as if I haven't thought about everything that I'm saying in the
Right.
course of the conversation. But hi, mom. By the way, my mom also is watching.
Hi,
Uh,
Ron. Mom.
but yeah, it, it's what they're it's unusual to have two sides where neither one of them has money, but crowdfunding has definitely been a game changer, and we're both grateful for that.
No, absolutely, obviously. But back to she
Thank you,
can't.
crowd.
Yes, thank you, everyone. Because again, this would not be possible without the support of people. I want to make that extremely, excruciatingly, painfully clear that I would not be able to be doing this without people. Yeah, exactly. My greater concern is my understanding of how law works when it comes to cases of wanting damages and things like that. And again, I'm no lawyer, nor do I pretend to be one on YouTube, but a lawyer typically doesn't take a case, and this doesn't follow what I'm about to say, but just hear me out. A lawyer typically doesn't take a case if they don't see that the person can pay the damages that they're looking for. I don't believe that's the case here. I believe they are trying to push an agenda to get a law passed or whatever. That's what I believe they're trying to do with this. That being the case, and what you just said, I don't believe Alyssa would have the financial resources to pay the anti-SLAPP. So then it goes into what is the game plan here? If she were to lose, how does the court handle that? Is it wage garnishment? What if she's not working? And how does the slap fully repair me if
It's
she can't do it?
it's not so much a slap question as a judgment collection question. It would be the same thing if a judgment were entered on basis of you're failing to deliver onions, or or breached a contract. In other words, slap doesn't have any special components to it. I guess the real question is, if in order to avoid wage garnishment, a person were to declare bankruptcy, would slap sanctions be dischargeable in bankruptcy? And they might not be, because bankruptcy frequently does not allow a person to be excused from penalties for intentional wrongs. But I'm not prepared to say how that actually would go without looking into it. We're far away from that.
Right,
But
right. I guess I'm just asking the questions that
I've
people
got
would
a
ask
better
me.
question for you, and you don't have to answer it,
Yep.
but you're going to be asked it. Let's say in a fantasy world,
Mhm,
not only did we get slap sanctions, but you collected them.
mhm.
You paid for this through crowdfunding. What do you do with the money?
That is a bridge to cross when we get there. All things being equal, I already know deep down in my heart of hearts that's not a concern that I have to worry about, because I almost feel like that's not ever going to happen. But if it were to happen, I've already talked to my wife, and we talked about this before we even got to this point. She is a oncologist, a cancer nurse, and we have a lot of compassion for people with cancer. And if this did not proceed to the point it already did, we were fully planning on donating a large, substantial amount of money to a cancer hospital, because I don't want this to be a financial gain for me at all. I don't want people to
Oh
think
no,
that I'm
no, you definitely don't. That I'm glad. I mean, I don't think I needed to hear that, but
yeah. This is not about, oh, I need to make money off this. It has nothing to do with, like, genuinely nothing to do with it. My bigger concern now, at the point we're at right now, is how am I going to afford to continue paying for this lawsuit if people do not continue to support it? But
they
thankfully,
will.
I've
They
had
will.
a lot of people that already say that they're there for me if we need it. So,
They will, and you will. Let's point out that there is the possibility that you could win, and they could appeal.
and most likely would, by the way.
Maybe, maybe. I mean, just if that happens, then the beast is going to require to be fed.
Right. Well, I fully presume that they're not gonna just let this go. They strike me as very rabid dogs that are just gonna keep going until they get their way, until legally they do get slapped down and be told, stop this. You're not going anywhere with this. Do not continue. Which I don't know if that's even something courts can even do, but I feel like that's where we're at with them right now.
The wheels of justice grind not only slowly, but at considerable cost.
Yes, they do. They
That's the
do.
price we pay for living in the greatest country in the world.
Yeah. My goodness. Well, with that being said, we've already gone a little bit over than what we expected. Did you have any final thoughts or closing things you wanted to say about it?
Jeff, you've been great to work with. You have your crowd, your friends, the gamer people have been great for me to get to know. I'm looking forward to getting to know more of you guys, and have help. All of you can also subscribe to my little YouTube channel.
Oh yeah, yeah. I'm glad you brought that up. I totally forgot. Yes,
Jeff will put the link.
I will
We'll
put the
have put
link
the
in the
link in
description.
but I mean, really, this is what I do, and it's you know, it's as Frank Burns famously said, it's nice being nice to the nice. Uh, Guys, it's been an incredible simulation of reality. Talk to you soon.
All right. Thank you so much again, Ron, and thank you everyone. Bye.
Maybe say, we don't want you around if you're going to be a
Yeah.
and hateful. And that the games industry is diverse naturally. Not because anyone's making them be diverse, because the world is diverse, you stupid motherfucker.
Smash and change.